Hello, and welcome to the Sunday afternoon in the Barnes & Noble parking lot podcast. Today, I will be your host, Gianni Mendez, and I have a few experts here to talk about the Madison v. Alabama Supreme Court case. My first expert here is...
My name is Claudia, and I will be talking about the precedent cases used in this case.
Hi, and I'm Tiara, and I'm here to discuss and explain the oral argument and what went on.
My name is Elena, and I'll be giving the background information.
And I will lastly be talking about the amicus briefs at the end of this podcast. So I would first like to begin this podcast by clarifying some background on this case. So, Elena, explain how the case got to the Supreme Court and what lower courts heard the case and what did they decide?
It started in 1998 when the Alabama appellate courts affirmed Madison's case and the Alabama Supreme Court denied the writ of cert in 2006. Then in 2009, Madison filed a federal habeas petition, which was denied by the district court. However, in April 2012, the Court of the Appeals for the 11th Circuit reversed the district court's denial for habeas relief and remanded the case for a Batson hearing. The district court held that the original prosecution did not purposefully exclude African American jurors. As a result, the district court denied Madison's habeas petition, which the 11th Circuit affirmed in 2019. Then the Supreme Court denied the writ of cert review, and in December 2017, Madison again challenged his execution based on competency grounds. On January 16, 2018, the Mobile County Circuit Court denied Madison's petition to stay the execution. And finally, the Supreme Court granted the writ of cert on February 2018.
Alina, can you explain why you believe the Supreme Court took the case and how Madison v. Alabama is different from the precedent cases?
Well, in order for a case to go to the Supreme Court, 4 out of the 9 judges have to agree to hear it. And I think the Supreme Court took this case because of its complicated past decision-making, along with its difference between the precedent cases and the importance of the interpretation of the 8th Amendment. The difference between the precedent cases and this one is the issues that were in the other 2 cases are coming together in the Madison case, and racial issues are also brought up, along with the view of his crime throughout the years has changed due to him developing a mental issue rather than committing a crime and having one. The whole point of this case is to raise a constitutional question if the 8th Amendment and the court's decision prohibit a state from executing a prisoner whose mental disability leaves him with no memory of the commission of the capital offense. So, Claudia, can you clarify or explain other precedent cases related?
So there were 3 precedent cases used. The first one is Ford v. Wainwright in 1986, and in this case, Ford was sentenced to death for first-degree murder, and the Supreme Court ruled that no one who is considered mentally insane could have the death penalty imposed on them because of the 8th Amendment of no cruel and unusual punishment. And Justice Marshall said that it was inhumane and savage to put someone to death that was insane. And Justice Powell said that the 8th Amendment forbids the execution only of those who are unaware of the punishment they are about to suffer and why they are to suffer it. Another case was Atkins v. Virginia, which was decided in 2002, and Atkins was convicted of abduction, armed robbery, and capital murder. And unlike Ford v. Wainwright, Atkins was declared mildly mentally disabled, and the Supreme Court said that people who are mentally retarded cannot be put to death by the death penalty, but that it was up to the states to decide what is considered mentally retarded. Therefore, it varies from state to state. In the last precedent case, Panetti v. Quarterman, which was decided in 2007, Scott Panetti was convicted of the murder of his wife's parents and sentenced to death. And also, unlike Ford v. Wainwright, Panetti understood why the death penalty was being imposed on him, but it was not rational. And in a psychiatric evaluation, Panetti was found to believe that the state was in league with forces of evil and was executing him in order to prevent him from preaching the gospel. So he wasn't thinking rationally. And each of the cases are based off the precedent of Ford v. Wainwright, but they all differ slightly because they all have different factors. One is mentally insane, one is mentally retarded, and one has a mental illness and does not rationally understand why the death penalty is being imposed on him, but he understands what he did.
So, Claudia, how are the rulings in Atkins, Wainwright, and Panetti all related? And what's considered mentally incompetent, since this seems to be a question to be raised in most of these cases?
So to be mentally incompetent mental incompetence is the inability of a person to make or carry out important decisions regarding his or her affairs. In Madison's case, he is considered to not be mentally competent because of his vascular dementia, which causes his loss of memory.
Thank you, Claudia, for that information on the precedent cases related to Madison v. Alabama. We will now be taking a short break, but don't go too far because in our next segment, we will be discussing the oral arguments with our next expert, Tiara. Welcome back to the Sunday afternoon podcast in the Barnes & Noble parking lot. We will now be talking to an expert on the oral arguments given during this case. So, Tiara, do you think you could give us a summary of the petitioner argument and the respondent argument?
Yeah, sure. So for the petitioning argument, Mr. Stevenson opened in reference to the Eighth Amendment and the Ford and Panetti standards and included their relevance to this case about Madison v. Alabama. And then the justices tried to challenge the petitioner's reasons and if Mr. Madison's circumstances even qualified him to avoid execution according to the Panetti or Ford standards. They just kept arguing that he's old, he's supposed to forget. It's not enough because any person in the older spectrum could have these issues. And as for the respondent side, the justices argued that his vascular dementia did in fact meet the Ford and Panetti standards, and they alluded to the Atkins v. Virginia case, that he also couldn't rationally understand his punishment without help. He couldn't rationally understand the reasoning behind his crime. It couldn't remember anything.
Okay, so Tiara, we have a few questions for you. So based on the moot court, what questions were raised in this court case?
There were quite a few questions by our justices. For example, Justice Roberts asked, does someone that doesn't remember the details of their crime, can he satisfy a Ford v. Panetti simply on that basis? He knows what capital punishment is, and he knows what's going on. He just doesn't remember what he did. So that is towards the petitioning side, and alluding to that simply not remembering is not enough excuse for him not to go on death penalty. And another question that was proposed by Justice Alito was, is his vascular dementia something that's considered strong enough to resemble illness to qualify for the rulings of the preceding cases? And another one, she didn't think that his old age or vascular dementia was enough to excuse him from being punished. And another question was from Justice Gorsuch, was that you stated that Mr. Madison doesn't have natural understanding in order for him to be competent for an execution. So if you're to explain to him that he's convicted of murder and is given the death sentence, what is your definition of rational understanding? So there's this ironic, we all know that he himself knows that he was convicted for murder. So what's really the problem here if he already knows what he's done? And those were the main ones.
Did the justices go off on any tangents during the case?
Oh yeah, there was this one tangent about the importance of the Supreme Court and what it really meant. So one of the respondents said, "If we build a society on the will of the people and do what is right for the greatest amount of people, then it is in the inherent system of the justice to secure the rights that would be most desirable for the society as a whole." And Justice Sotomayor clapped back with, if you were to assume that the purpose of the court was recognized important, the people in determining a punishment through a democratically elected body, then what is the purpose of an appeal system? And what's the purpose of this court system sitting right here? And the purpose of the court is not to serve the people, but rather to rule what's constitutional. And that's when Roberts kicked in and he said that they're mixing up the questions, and they got back on track.
So did you happen to hear of any humorous moments in the moot court?
Well, in a typical court case, or in any case in general, it's not really a comedy club, so there weren't really any outstanding humorous moments, you know?
Yeah. I guess the last question is, who did you notice talked a lot and who talked a little bit?
So Justices Sotomayor, Chief Justice John Roberts, Alito, they were among the few that really moved this case forward. But I noticed that Justice Thomas and Breyer didn't say much, especially Thomas. But yeah, just an observation. Oh, and can you explain to us, Gianni, the host, what the amicus briefs were all about?
So we have 2 amicus briefs that were submitted to the court case. We have the National Association of Police Organizations in support of respondent, and we also have the American Psychological Association and American Psychiatric Association of Amici Curiae in support of the petitioner.
Interesting. So could you explain why the organization submitted those briefs and why did they care?
The American Psychological Association and American Psychiatric Association are in support of the petitioner because they would like to help and apply their knowledge into this case, since that is their expertise, and it is important to them to promote health, education, and welfare within their society, according to the brief for the American Psychological Association. Many of the workers or members in this association have worked in or have experience with the criminal justice system. The association and its members are very well educated and have relevant experience that relate to the issues that will be discussed within this case. The National Association of Police Organization is in support of the respondent because they represent law enforcement officers across the United States, and it is dedicated to advancing their vital interests. They also endorse many other acts that support law enforcement, like the Blue Lives Matter Act, the Thin Blue Line Act, and the Back the Blue Act, all of which seek to increase penalties for those who intentionally seek to harm law enforcement officers, with the latter 2 looking to make this an aggravating factor in death penalty determinations. And this could all be found in the amicus brief provided to the cases.
So how does the organizations want the court to rule, and why?
The National Association of Police Organization would like the justices to rule in favor of the state of Alabama because they believe that it would be deeply insulting to the law enforcement community for the court to declare Madison less culpable now because he cannot remember the victims in his crime. 2 reasons for why they believe in their decisions are: number 1 being there is nationwide support for increased penalties for the murder of law enforcement officers, and 2, the death penalty serves an important function as an expression of community outrage against the murder of police officers. However, on the other hand, supporters of the petitioner, like the American Psychological Association and the American Psychiatric Association, both state that it has been concluded by mental health professionals that Mr. Madison does have signs of dementia and that these victims are not simulated or fabricated. Both associations have no doubt, according to the studies, that Mr. Madison does lack rational understanding, so this execution would indeed violate the Eighth Amendment. The reasons for why they believe in their decision against his execution are: number 1, executing a person with severe cognitive impairments caused by vascular dementia counts as cruel and unusual punishment. Number 2, mental health professionals can reliably diagnose severe neuropathology and determine an individual's capacity, which leads the associations to conclude that the decision of the Mobile County Circuit Court should be reversed and rule in favor of Vernon Madison. With that being said, we would like to conclude this podcast with our predictions for the outcome of this case. We believe that with the regarding evidence from the petitioner's attorneys and his incompetency, that the justice will rule in favor of the petitioner, Vernon Madison. We believe that the majority opinion will conclude that the Eighth Amendment prohibits the execution, whether that inability is due to psychosis or dementia. The justices voting in favor of Madison will most likely be Chief Justice Roberts, Justice Ginsburg, Breyer, Sotomayor, and Kagan. The justices opposing the decision will be Justice Thomas, Alito, and Kavanaugh. Thank you for listening to our podcast, and we hope you have a great rest of your day. Thank you.